Hello everyone, I am Dr. Pratibha Chauhan from Sri Shivaji Law College, Parbhani. This is the second video on the classification of administrative action. In this video, we will see what are the executive power of the president and who comes under the head of the executive and what are the powers of administrative authority as well as the quasi-judicial authority. So let us start. The executive power of the president given under Article 53, Clause 1. It provides that the executive power of the Union shall be vested in the president and shall be exercised by him either directly or through officer subordinate to him in the accordance with this constitution. He is not the real head. The Prime Minister is the real executive. Even then, all officer of the Union shall be his subordinate. Prime Minister shall always inform the President regarding the decision and information from time to time. All the important dignitaries of the state are appointed by the President. Even the President have the power to remove them from their service subject to the provision of the Constitution. Such dignitaries are Judge of the Supreme Court, Chief Justice of High Courts, Judges of the High Court, Governor, Prime Minister and his co-ministers. Even Auditor General, the Finance Commissioner, Attorney General for India, 3 Chief of Navy, Army and Air, etc. Now, we will see what are the administrative function. An administrative order is generally based on government policy. Administrative decision, there is no legal obligation. Administrative authority is not bound by procedure law, such as CPC or evidence. Administrative authority can make decision in the exercise of the statutory power. Administrative function may be delegated and sub-delegated. Even they can use the discretion. Means whenever they used to take any administrative decision, then they may use their discretionary power. Administrative authority is not always bound by the principle of natural justice unless the statute casts such a duty. Administrative order may be held to be invalid on the ground of unreasonable. Administrative action will not become a quasi-judicial action merely because it has to be performed administrative authority. The prerogative, writ of certiorari and prohibition are not always available against the administrative action. Administrative and quasi-judicial function. Act of an administrative authority may be purely administrative or may be legislative or judicial in nature. Decisions which are purely administrative stand on the wholly different footing from judicial as well as quasi-judicial decision, and they must be distinguished. This is a very difficult task. Where does the administrative end and the judicial begins? The problem here is one of the demarcation and the court are still in the process of working it out. What is the object? It increases the power of administrative authority. It may be necessary to provide a guideline for just exercise thereof, to prevent the abuse of power and to see that it does not become a new despotism. Court follows certain principles that have to be observed by the administrative authority at the time of adjudicating the case. They appreciate the distinction between administrative and quasi-judicial functions. We have to understand two expressions. They are lis and quasi-lis. So this distinguish it is seen in the case law, namely Province of Bombay versus Khulchal Das Advani. Lis means a suit, an action, a controversy in the court, a dispute. Quasi-lis means it decides not between two or more party, but between itself and another party. Justice Das observed, if a statute empowers an authority to decide the dispute, crisping out of a claim is opposed by another party and to determine the respective rights of the contesting party who are opposed to each other, this is a lis. An administrative authority is required to decide the dispute between the party and to adjudicate upon the lis prima facie. In such a case, the authority will be regarded as acting in quasi-judicial manner. Administrative authorities have been held to be a quasi-judicial authorities and their decision regarded as a quasi-judicial decision which in such a lis was present. For example, a rent tribunal determined the fair rent between landlord and his tenant. An election tribunal deciding an election dispute between rival candidate. An industrial tribunal deciding an industrial dispute. Licensing tribunal granting a license or permit one of the applicant. Now, what is the definition of quasi-judicial function? So, quasi-judicial frequently used a strongly criticized term. Quasi means not exactly but similar to the term quasi was used by the English court in 1930 and 1940. C.K. Allen called this term the ghost land, that is a quasi. Now, what is the definition of the quasi-judicial function? This act can be defined a judicial act only when it is exercised by an ordinary court. When the same act is exercised by an administrative tribunal, it will be called quasi-judicial. However, this view has been modified in Union of India versus Paras Laminate. The Supreme Court has observed that a tribunal may function as a court within the limit of its jurisdiction. A judicial decision has four main characteristics. Number one, the presentation of the case, not necessarily orally of their case by the parties to the dispute. Second one is, if the dispute between them is a question of fact, a fact means of evidence, argument by or on behalf of party on the evidence. Third one is, if the dispute between them is a question of law, the submission of legal argument even by the party. A decision which disposes of the whole matter by finding upon the fact in dispute and an application of the law of land to the fact. Now, what are the quasi-judicial functions? Quasi-judicial functions are the disciplinary proceeding against any student or any subordinate authority, a dismissal of an employer on the ground of misconduct, confiscating of the goods under the Sea Custom Act 1878, cancellation, suspension, revocation or refusal to renew the license or permit by licensing authority, determination of citizenship, determination of statutory dispute, power to continue the detention or seizure of goods beyond a particular period, refusal to grant no objection certificate under Bombay Cinema Regulation Act 1953. Next, for regarding the pension or gratuity, an order of assessment under the taxing statute. So this way we had completed this second video on classification of administrative action. Thank you.